Good afternoon, everyone. My name is Sandy Upchurch, and welcome to our webinar today. This is definitely a family affair today. My wonderful father-in-law, John Upchurch, will be presenting, and his topic today is Getting Ready to Mediate, a Blueprint for Success. And so I welcome you, John. How are you?
Well, I'm just fine, Sandy. Thank you.
This is such a pleasure that we're able to finally do this. John has done several webinars before, but this is the first one we've done together, so this is fun. It's going to be like a conversation around the dining room table, I would imagine, for us today.
Looking forward to it.
We have over 200 people registered for your webinar today, which is probably one of our firm records, which I'm very, very proud of. For all of you that are listening in, I hope that our technology is working. We've been testing it all morning, and it looks like everything is on go from our end. I hope it is on your end. If you all have any questions you'd like to ask today, there should be a toolbar on your screen, and there is a section there entitled Questions. You should be able to open up that section and send me a question. And if we have time today, we'll try and answer it as we hit the topic area or at the end of our session today. If you do not want to see that toolbar and you just want to hear John's radio voice, that's fine. Go ahead and click the orange arrow that's on that toolbar. The orange arrow is facing to the right. If you click on that right arrow, the toolbar will go away and all of that stuff will be out of your way. Don't forget also to try and maximize your screen that you're looking at. Up in the right-hand corner, hit that big, large window button so that you can get the full benefit of the slides that John has prepared for today's webinar. Like I said, we will offer this is an offering of 1 hour of CLE by the Florida Bar. The course number will be provided at the end of the webinar on the last slide. If you have to pop out a minute or two early, just let us know via email, and we will send you that CLE information. But I know that you're going to be sticking around to the end. Well, I think I've already kind of hit the basics here for what I wanted to go over with housekeeping matters. Let me introduce you formally to my father-in-law. He is one of the founding partners of the firm, Upchurch, Watson, White, and Max. We are a full-time mediation group and do not do anything other than mediate, arbitrate, and perform special master functions around the country. John began the firm in the 1990s, early 1990s, and was on the very, very, very first wave of ADR in the state of Florida. And he and Larry Watson together helped actually develop the beginnings of our ADR rules in the state of Florida, which is something that our firm is terribly, terribly proud of. I am proud because he is my father-in-law, and I have learned from the finest and the best, in my opinion, my humble opinion, and my self-serving opinion too, which does make Thanksgiving dinner and Christmas dinner all that much better. So without further ado, Dad, John, I'm going to turn this over to you. I'm going to interrupt you occasionally every once in a while because, as you know, I have lots of questions. So I'm going to pepper you with some today, and hopefully our guests online will also be peppering you with some of their questions. So John, tell us a little bit about Getting Ready to Mediate and what the blueprint for success is.
Well, thank you, Sandy, and delighted to be here. Delighted to hear that so many attorneys have registered to participate today. Welcome. We're very proud of this webinar series. We try to present at least once a month. Sandy is the driving force behind this series, and Sandy, thank you very much for all you do, both today and in producing this valuable series, providing CLE free of charge to our clients and friends and colleagues throughout the state has been a tradition of the firm, and with the advent of webinars, we're able to greatly leverage our work and get a lot of pleasure in providing this. I'd also like to mention and congratulate Sandy that on her ascension to the bench. She ran for circuit judge here in the 7th Circuit. She was not opposed, and so when qualifying closed, she was deemed elected. And so in January, we're going to lose her as a mediator, and Sandy, we'll miss you greatly.
Oh, thanks.
But the lawyers and citizens of the Seventh Circuit will greatly benefit by your fine touch as an incoming circuit judge, and so we'll miss you.
I'm just following in your footsteps. That's all.
Well, that was a long time ago. I must say that I have found mediation to be the most extraordinary development in the administration of justice in my career. It was fortuitous that I was a judge before mediation came into play, but once it arrived, I realized that my career path would be channeled in the mediation direction, and it has been ever since really the late 80s. But at any rate, hopefully some of the observations that I've had over the years will come into play today, and I hope to share some of that with you. I've decided to start with simply setting the stage, and let me say today is going to be less about getting ready on the issues and the law and the investigation of the case. It goes without saying that prior to coming to a mediation, it's necessary to be very well prepared in terms of your investigation and legal research and so forth. That in and of itself would be the subject for a separate presentation. But my emphasis today will be on advanced planning and preparation of the client, the mediator, the opposition, and all of the players in the mediation conference. I think it goes without saying that in-depth, careful preparation is critical in leading to a favorable settlement. I like to say that it's analogous to trial by notebook, which breaks the trial preparation into various phases leading to coming to trial. Mediation lends itself to the same sort of approach. I'd like to recommend a detailed checklist for each element. The elements we'll be going through today with the thought that you wouldn't show up at a trial just trying the case by the seat of your pants. And I think the same general observation goes to mediation as well. Unfortunately, we often see, I've even seen people actually meeting their client at the mediation for the first time, which tells me that we're not likely to have a very effective session. But effective pre-mediation preparation starts far before the date actually set for the mediation. Although selecting the mediator isn't necessarily the first thing we're going to approach, often it is. And so I thought we'd go ahead and cover some points on mediator selection initially. It's really important to choose carefully, keeping a number of factors in mind. The most apparent that we often hear cited is the mediator should have subject matter expertise. I like to ask, is this absolutely necessary, especially if it's a fairly esoteric case? Most mediators have been very good lawyers. I like to say we're all quick studies, and with good pre-mediation submissions and an opportunity to prepare from the mediator's point of view, any subject matter can probably be conquered, at least to the extent necessary to conduct an effective mediation. But I would suggest that you, as the attorney representing a client in mediation, should be much more focused on the mediator's process expertise. Check reputation references for effectiveness in conducting mediation sessions. If you're selecting a mediator in another jurisdiction, needless to say, a prerequisite would be to be certain that your proposed mediator has the appropriate training and certification. Of course, in Florida, circuit court certified mediators are plentiful. There are exceptions, that is to say, parties can stipulate in a given case to use actually any person as a mediator. However, it would be unconventional not to select someone who's had proper training and certification. What I'm advocating is really covered in the next point, and that is to investigate, be sure that you find someone with the appropriate credibility, gravitas, maturity, someone who's accustomed to dealing with people, someone who's not intimidated perhaps by a famous lawyer on the other side or a famous party on the other side, but someone who feels at home no matter who may be around the table and can deal with them effectively. And of course, the housekeeping details, being sure that facilities are available, the cost is appropriate. Some mediators are much more expensive than others. I acknowledge my hourly rate is probably beyond what some routine matters may call for, but I like to say personally, when it's a bet the company case or perhaps millions of dollars are at stake, the cost of the mediator isn't much of a factor, and most mediators' fees are set in accordance with market demand and their experience, their ability to handle matters of extreme complexity, multi-party, and all the rest.
Don, would you say that it's important to hire a mediator that is going to best communicate with your client, is someone that you know your client's going to listen to, whether it's someone who is very gruff and to the point because your client needs that, or whether someone that's more empathetic and a listener because that's what your client needs? Is there a matching of client and mediator character or quality?
Yeah, yes, and we're going to get into working with the client and making judgments as to the personality of the client, the personalities involved on the other side, and a judgment as to whether the personality of the proposed mediator is a good match. And even some introspective analysis is appropriate here. But one should ask himself or herself, am I more comfortable with a facilitative, softer mediator? Am I more comfortable with someone who has a stronger personality, who perhaps may be a bit more evaluative in their approach? Of course, all this keeps in mind the standards in Florida prohibit mediators from evaluating. But that's an awfully tough definition, and I think the truth of the matter is there are many shades of gray, and so whether it's being directly evaluative or implicitly evaluative, most parties and most attorneys at least often desire a mediator that will help guide and shape their decision-making process as agents of reality and pointing out what well may happen in a particular case if it's not settled. But yes, the personality of the mediator is extremely important, and of course that if one has not had personal experience, that's something you would investigate as you do your due diligence on the background of the mediator. Another point I'd like to raise, sort of a first cousin of that, is especially in a case where you don't anticipate settling immediately, if the issues are profound, the case is complex, you want a mediator who's got a reputation for tenacity, for perseverance, this has come to the point where mediation is really defined as a process, not necessarily just a date on the calendar. And if the mediator starts at 9 o'clock and then if the case doesn't settle by mid-afternoon or late afternoon or into the evening, whatever, the parties break up for the day. If the mediator considers the mediation over from his or her perspective, you're missing a bet. You want someone who's tenacious, who will persevere, who will follow up, who won't give up. And I just think that's a critical component to finding an effective mediator. So, well, let's move on a bit. In terms of our overall preparation, the most important preparation, of course, is with the client. And this is the antithesis of the situation I mentioned earlier with the attorney meeting the client for the first time at the mediation. That always signals to me that our client interview is going to take place during the course of the mediation, which is probably just a frustrating initial exercise that will inevitably be followed by another mediation.
I always cringe when that happens too, when they walk in and they haven't met and they say, "Oh, it's great to meet you." You go, "Oh boy."
Well, I think if I were still practicing, I would develop a template, and that's what I recommend. I recommend that a series of questions be reduced to a questionnaire, and I thought about attaching something to the materials, and I will may to the materials that are ultimately published. But my point is, for this to be meaningful, it has to reflect the practice and the personality of you, the attorney. But the point is, you should have a detailed, lengthy interview with your client for the purpose of building a solid foundation leading forward to the mediation. Beyond just discovering the sequence of events and the facts and the basis of the dispute, it's important to have discussions about what are your goals, what do you feel you want, what do you really need, what is critical, what may not be so critical. Let's prioritize. What do you think are the strengths of the case, the weaknesses of the case? From the opponent's perspective, what do you think your opponent's strengths and weaknesses are? All of these questions would lead to solid conversations which will give you insight into your client and even insight into your own feelings about the case. Non-monetary needs. Court actions are all about, for the most part, are all about money. But one wonderful thing about mediation is we can often expand the pie and address issues that aren't necessarily at stake in the litigation. Certainly an investigation about any continuing relationship with the parties. We have cases all the time in which corporate parties have independent commercial relationships. And so a question is the litigation interrupting a favorable relationship with respect to this other area of contact? Who are the executives involved? Who plays golf with whom? How can we spark some interaction that might be helpful in getting the case settled? How important is a speedy resolution as opposed to perhaps taking more time? So these are just examples. There are dozens of such questions that would go into a comprehensive template. You wouldn't necessarily focus on every question in every case, but the point is to dedicate a couple of hours with your client to lay the groundwork for your ultimate preparation for the mediation. Next, I'd like to talk about preparing the mediator. Many people have their first interaction with a mediator as the mediation begins. I think this misses an opportunity. I think there are a couple of chances to interact with a mediator on a very effective basis in advance of the mediation. I'll often get a call, especially from someone out of state or someone at a distance, who will say, "John, you've been recommended, you've got a great reputation, but I'd like to chat with you. I'd like to introduce myself. I'd like to chat with you about some of the issues I see in the case and perhaps glean some idea of your approach to a mediation of this type." And well, I consider that a job interview. I mean, I'm in business. I'd like to land the assignment. So I'm going to take whatever time's necessary to satisfy this person that I'm a good mediator, that I'm tenacious, that I'm well prepared, and take pride in my work. But meanwhile, that person is making judgments, I would assume, about my approach, whether I inspire confidence during the course of the conversation, and the like. So, and then that's followed by, and we'll get into the pre-mediation summary and the pre-mediation conversation, if indeed it's appropriate in that case. So by the time the mediation rolls around, especially in a significant case, you should have already had a couple of conversations with that mediator, and hopefully have identified special problems associated with the case, personality issues, esoteric legal questions that might require some extra preparation. So that's all in the arena of preparing the mediator to set the stage for an effective mediation.
John, I'm wondering if you might be able to move that mic just a little bit closer to your mouth. Just, I think we have a couple people that said you sounded great, and a couple people said that if you could be a little louder, that would be great. So I don't know if you need to.
Sure, I've done that, and hopefully this will solve that problem.
Okay, sounds good to me.
I hope those who are having problems will comment to Sandy, and we'll make any other adjustments that might be necessary.
Yeah, one thing I could tell them too is if they are listening via headphones, they could adjust the volume on their headphones too, as you know, to make you a little bit louder. So.
Good. All right. Well, the third component of preparation at this phase, I've simply labeled prepare the adversary. It's good if one has a few conversations with opposing counsel about the mediation. Of course, it's a given that you're going to have communication with opposing counsel on who the mediator is, in that you're going to stipulate in the ordinary case as to the identity of the mediator in that case. Which reminds me something I might have covered earlier, but I think it's an important point. I've heard lawyers go both ways on the question of what to do when your adversary suggests a particular mediator. Some lawyers say, I don't care who the adversary suggests, I'm going to go with that person because they're comfortable with that person, and I can deal with any personality type as far as a mediator is concerned. And I've heard just the opposite. I'm not going to cooperate with my adversary and go with his or her mediator. That's the last person I want. Well, I think the advice would be to take that into consideration. Do the due diligence if you're not familiar with a mediator on your own. But I come down on the side if the mediator seems qualified and you feel that you would be comfortable with that mediator, it's probably a plus to go with someone the adversary is comfortable with.
I agree with you. I definitely agree with you on that one.
Yeah, because that way you know the person comes in, they don't have a chip on their shoulder vis-a-vis who the mediator is, and so it's, on balance, it's more likely to set the stage for a successful mediation. Let me move on to...
Just, there you go.
There we go, okay. I've labeled this opposition research, and this is really a topic that would be part of that client interview process to a large extent, to the degree that that your client is informed as to who's on the other side. Some of this may come through your conversation with opposing counsel. Some of it may come through researching business information on the web or through an investigation. But it's in terms of preparing for the mediation, figure out who you're going to be dealing with. It will impact your strategy in your approach to the mediation. If we're dealing with a business executive, or we're dealing with a claims person, or we're dealing with a personal injury claimant, what type of personality are we dealing with? Are we dealing with someone who's directive? Are we dealing with someone who's meek? It all comes into play in terms of thinking about what approaches might appeal to that particular type of person. Getting into their perspective of issues financially and in terms of business, what are their interests? A lot of this is simply fine-tuning what the interests of the two sides are. Of course, it's a lot easier for you to determine what your interests are, or your client's interests, but it's equally important to determine what your opposition, your adversary's interests are, both in terms of the client and opposing counsel. You probably, in going through the beginning stages of the litigation, if not through just your general knowledge of the legal community, are familiar with the experience and reputation of your opponent. But if you're not, check that person out, because that will play a role in your preparation. But what we're trying to do in a mediated settlement is identify options that meet the interests of both sides. Broad enough options to satisfy the fundamental interests of both sides. And so in your preparation, be sure to keep that in mind.
I grabbed a hold of that keyboard for a second, so you need to grab it back from me.
Okay.
We're already getting requests for copies of your PowerPoint, so that was one of the questions I was answering on offline.
Well, good. Well, of course, we'll certainly make that available.
Yeah, we're going to post it, everybody, on SlideShare. That's our preferred methodology. And then, of course, after the webinar is over, the recording of this, including the slides and the audio, will be posted on our website for any of your colleagues that want to listen after the fact and still get CLE credit.
Indeed, we always make copies available, and although I guess we have a copyright there, I'll invite anyone who wants to use the slides to do so, and if you don't feel confident, send me an email. I'll grant you a license to use them for whatever purposes you wish. Our whole idea here is to spread the word, and to the degree that these ideas are helpful, we want them to get the widest exposure. We alluded to this a little bit earlier with the mediator. Again, this is a point of contact with the mediator, which can be very useful. The mediator can be an instrument to prod the opponent to comply with necessary discovery. The mediator can be an authority figure to urge and stimulate your opponent's preparation, which is just as important as your preparation in coming to the table with the idea of having an effective mediation. Authority is critical. If you're representing the defense, move heaven and earth to get the appropriate party there with authority. Lament of the mediator. If that's not possible, please at least have a telephone number and make arrangements with the person who must be checked with to be available during the course of the day so that the conversation can take place. I would also urge you to discourage the authority figure who may be appearing over the phone from refusing to deal directly with the mediator. More cases settle when the mediator and the authority figure can get to know each other, even if it has to be over the phone. Not optimal, but if it's the person behind the curtain and there's no direct communication, it's very difficult for them to really pick up on the nuances of what's happening during the course of the mediation. If the mediator does not routinely telephone the parties, telephone counsel to discuss the case in advance, I would suggest that you urge that happen. You will want to speak with the mediator in order to, if nothing else, precondition the mediator as to your special issues, your client's personality quirks, perhaps talk about personality quirks that you've identified on the other side. But if the mediator is warned, the mediator can be thinking about how to handle these items, and it also gives you an opportunity to talk about things you wouldn't feel comfortable putting in writing, such as the personality issues that I just alluded to. I'm not going to go into great detail on the preparation of the mediation summary because this will be the topic of a subsequent webinar. Howard Marcy, one of our stellar members, is going to focus a webinar presentation in October on this topic, which is very important. But some of the highlights that I'd like to mention in passing today. There's not just a stock template for a mediation summary. It's very important for the author, that's you, to determine the purpose or purposes of the summary. It's a great opportunity to educate the mediator. I mean, that's the basic purpose. But it's also a means of informing your client in a very straightforward, organized manner of your analysis of the case at that point, including all of your investigation, your legal research, your interpretation of the interview with the client, and how you're going to present your case to the mediator and perhaps to the other side. It's a wonderful opportunity to influence the opposition. I don't see why anyone would voluntarily refrain from being able to file, if you will, a persuasive brief directly with the opposition. And it's an opportunity to shape the negotiations, or at least begin to shape the negotiations.
You know, John, I just don't think that's done very often, and I don't understand it. I think that a very well-written mediation summary provided to all parties is exactly what you just said. It's one more opportunity to taint the well, to be persuasive, to get your point across, and people don't take advantage of that opportunity. And I think what you just said is bears repeating. You can do a private one to the mediator that might include some of your secret stuff that you don't want to disclose. But what are you holding it back for, and why aren't you providing something in advance? I don't understand that. I wish I saw it more.
Well, and it may be a product of people being too busy or not having enough time to do the kind of job that they would be proud of and want to publish. You touched on really the solution to the problem. If there are aspects of the summary or the communication with the mediator that you really would prefer not be shared with the other side, there's no reason in the world you can't share a confidential addendum, making it very clear to the mediator that this is for his or her eyes, ears only. And if it's extraordinarily sensitive, make it the subject of a telephone call, so that there's no written record of it. But if something is not shared with the other side, especially if the other side has a group decision-making process, a board of directors, a client or a claims committee, the more information, the more persuasive information that's provided to them in a timely manner, the better your opportunity is, it seems to me, to be persuasive. It also is an opportunity to demonstrate your mastery of the case, your mastery of the facts, the law, all the rest, in order to hopefully set the stage for settlement with the other side. Now, the downside is what I hear is, well, they'll discount all of my points, or it gives them an opportunity to prepare. And by the time the mediation rolls around, they'll have freshly prepared defenses. That's a judgment that simply has to be made. But in today's atmosphere of open discovery, all of those factors are going to come to the surface anyway, well before trial. So you might as well take advantage of the chance to affect their approach to mediation, it seems to me. But the rest of this is fairly apparent to be objective. If one is over the top, making unwarranted exaggerations, then you're wasting your time and energy. You won't be taken seriously, and that would hamper the opportunity to settle the case. I've got a note there, decide timing, especially if you anticipate a wide audience in the decision-making process, and with the probability that all of those audience members will not be personally attending the mediation. Get it out early so that it can be reviewed by the claims committee, or it can be reviewed by the board of directors. So let's move on. The clock is ticking here.
It sure is. I can't believe how much time we don't have much time left. So I'm
going to skip the next, but I am going to. And I also think that Howard is presenting his course on preparation of the effective mediation summary in person in Maitland sometime within the next week or two. So if anyone is interested in attending the in-person luncheon presentation in Maitland, be sure to send us an email. We'll get the information too.
Howard is a fantastic writer, speaker, and presenter. So I try and attend anything that Howard's giving for sure.
In setting our goals for the mediation, at some point I had an aha moment, and I realized that every mediation is challenged by ordinarily many potential pitfalls, and so success equals the total elimination of all those roadblocks to settlement. And so what I'm advising is take some time during your preparation, beginning with the client interview, to begin listing potential roadblocks to settlement. Identify those threats in advance so that you can begin to strategize, okay, how do we make sure that someone in authority is attending the mediation, or deal with a tough personality type. Now, I've got a list in the materials here of just some examples, just to point out how many of these there are. We don't have time to discuss all of them. Lack of authority, personality problems, greed, revenge, bad feelings, an urge to punish. Someone is psychologically attached to the case and can't let it go. I'm reminded of Judge Ito in the O.J. Simpson case. They say he needed some psychological counseling when the case was over because he had become so famous and had become so addicted to being on television and being identified with the case that when it was over he felt he'd lost part of his personality. I have had very unfortunate situations where perhaps parents, in the case of a wrongful death in a child, they just become so involved in the case becomes their life, and the idea of settling the case and ending the litigation and ending the interaction with the lawyers and ending the interaction with the court is a threat. And so that can be dealt with, but it's important to identify it in advance and then perhaps involve opposing counsel, involve a mediator in order to effect a strategy to ease them away from that psychological attachment to the case.
I think the number one I get is on your next list, which is more factors that cause impasse, and that's the principle. People say almost every mediation I am involved in, we're not settling. This is the principle. This is more than the money. This is the principle. And I have to kind of take them aside and caucus and talk about principle and talk about practicality and talk about financial decisions and business decisions. And principle is not going to put money in your children's mouths, and principle is not going to make you feel better when you leave here today, get the monkey off your back. And principle to me is the number one hurdle for my mediations.
And often in mine. That's a very good point. Often with the party accepting money in a settlement, I'll make the point that you're guaranteed for the rest of your life, as you reflect back on this case, the memory that the other side paid money to settle the case, which is an implicit, whether the language of the settlement agreement so states or not, it's an implicit admission. I think psychologically, from the standpoint of the settling party, can be taken as an implicit admission that they were wrong, you were right, and we're paying you money to settle the case. But yes, that's often a problem for the mediator. But my point here is, it's good if that could be identified in advance, and perhaps the mediator involved in thinking about how to address that particular problem. All of these are interesting and can lead to a discussion beyond the time we have available today. I have here jealousy among co-parties looking sideways. Think of allocation problems when there may be 3 or 4 defendants in a case, perhaps a complicated accident. I had a case, Sandy, that you and I worked on with involving an oncoming truck that struck a school bus.
Yeah, I remember that.
Turning onto a highway with many injuries. Fortunately, only one death. 20 or 30 injuries. It was a big case. Took us 2 or 3 days to get it settled. But one of the biggest problems was the defendants were all going to contribute to the settlement, but it was overcoming their institutional jealousy as to who was paying more than the other. And that's in construction cases, when we have multiple design professionals, subcontractors and the like, they're all anxious to settle the case, but none of them wants to pay more than the other subcontractor who they think was even more responsible than they were for causing the ultimate loss. So that problem bears analysis in advance and thought and discussion among the lawyers and the mediator in order to overcome it. I have up here mediator's frustration. I hope I'm not confessing to anything personal.
I was going to say, you've experienced this? Wow.
I've heard anecdotes that mediators get frustrated, have a bad day, and declare that they've had enough, and the case is impassed, and so forth. So that can be a problem as well. And so the well-informed attorney will anticipate that, perhaps suggest a delay, or even a let's take a meal break, although I don't ordinarily recommend meal breaks. But if you're there and you want to get your case settled, you might have second thoughts just about the ability of your mediator in that particular case. But be aware, mediators are human too, and they can have a bad day. They can have pressures going on. And
John, we've gotten one question that I think is on topic. If you don't mind we've gotten several questions, but this one is from Norm von Birch, and it's on topic about potential for impasse and causes of impasse. And he's talking about the very emotional client, primarily maybe at a probate mediation, but we've experienced them in wrongful death mediations for sure. And his question specifically is, as a lawyer or the mediator, which is the best way to handle in advance clients who will come to the mediation in an agitated and emotional state? Obviously, those pre-conference meetings with your client are a long way to doing that, and perhaps a pre-introduction to the mediator would be helpful. What are your thoughts?
Well, in an extreme case, perhaps arranging an in-person meeting with the mediator in advance. Occasionally, either at my suggestion, but commendably at the suggestion of counsel, I will meet separately in advance of the mediation with the party, together with counsel. Ordinarily, it's for that very purpose, to become personally acquainted, to be in a position to reassure the person that this is a relatively informal process, that it's diplomatic, nothing's going to be forced down their throat, that we're going to have a conversation in order to seek a diplomatic, non-adversarial solution to the case, and so forth. But certainly keying the mediator in advance is important. Getting there early on the day, another opportunity to interact with the mediator in advance of the mediation is the day of the mediation, especially if it's at the mediator's office. There's no reason you can't show up 10 or 15 minutes early, maybe 30 minutes early. Maybe by arrangement 30 minutes early.
Right, right.
And that gives the mediator an opportunity to calm the waters before the mediation.
John, too, before you leave the slide, Jay Plotkin is asking about the lien issue. He says he wants to know what thoughts you have about liens before you specifically leave this slide.
My frustration about liens is that the negotiations with respect to liens are either postponed until after a proposed settlement, if you will, or take place during the course of the mediation. This is kind of like meeting the client on the day of the mediation. And my question is, why in the world weren't these conversations taking place in advance of the mediation, so that perhaps 3 or 4 apparent scenarios could be field tested, so that the settling party is in a position to deal with the lien holder. But the most common concern I have is lack of investigation, lack of communication, lack of preparation on the lien question, and then just citing it as an obstacle during the course of the mediation. So, Sandy, we're really running short. So
we are. I was just going to say, I feel a part 2 coming on, John. You think you might be game, maybe next month or in August?
Well, we'll certainly think about that. I think I can go through the preparation of introductory themes. This is, in effect, putting it all together, getting ready for the mediation, your opening presentation. This can also be the themes of coaching the mediator to present similar messages. Some of these are appropriate for the mediator to give in his or her opening, but just a few favorites. I think it's effective to acknowledge there's not going to be a Perry Mason moment. I've never seen someone stand up in a mediation and say, they're right, we're wrong, I apologize, in terms of overall responsibility. That's not to say I haven't heard an apology for the accident and so forth when the case is all about damages. But there's never a sudden capitulation. This is suggesting that compromise would be the order of the day. Go to the balcony. This is simply suggesting that the parties try to put themselves in the mindset of being independent observers. Go to the balcony, become critics at a play, put yourself in someone else's shoes, and look at the evidence through the eyes of a third party as opposed to through your own eyes, which may be, which undoubtedly are subject to bias. Perspectives are different. I don't think we have a way of surveying the audience, certainly not in the limited time we have available, and I now see we're getting into overtime. But sometimes the use of an illustration can show that perspectives can be different. Some people here will see a gentleman playing a saxophone. Some people will see the outline of a beautiful young woman to the right. Very few will see both immediately. And so that's sometimes an illustration like this can be fun and can make a point.
I didn't see her, huh? I gotta look at that again.
I like to suggest that certainly the mediator, but counsel as well, set a positive tone. Make it convey the idea that your expectation is that at the end of the exercise we're going to get to a settlement. I think that's important. I like to point out that the parties decide, the lawyers advise, and if your opponent is an overbearing sort of attorney with a meek client, there's nothing wrong with looking the client in the eye, saying, Mrs. Jones, this is your day, this is your case, you're the one who decides. Mr. Smith, your attorney, is an esteemed advisor, and I know will give you the best advice he can. But in the end, it's your case and your decision. I've occasionally seen this work effectively when an attorney may be particularly, for one reason or another, recalcitrant. Usually the attorney will signal if he or she is ready to settle but doesn't quite want to, maybe would lose too much face in terms of the advice they gave pre-mediation. They'll throw it to the client and say, well, you guys have a conversation, I'll go outside and I'll be happy to abide by what you decide. And often that'll get the...
John, we are running definitely overtime, and I don't want anyone who has an appointment at 1 o'clock to miss out on the opportunity to see what our CLE information is. Could we maybe do a rain check and check in with you later on next month or later on in the summer? Or would you like me to go ahead and go to the last slide and then you can continue on for anyone that wants to stay on? What's your preference?
Absolutely, Sandy. I think we're around the final bend here, so go ahead and go to the last slide, and let me just thank our audience for your patience. I hope this has been helpful. We'll certainly post these slides on SlideShare.